Here we go. Now I'm seeing all these wonderful people. Hi, everybody. Put a hello in the chat or raise your hand or something. Just acknowledge that you're here. There we go. And get some raised hands. Hi, Monique. Hello, Amanda. Yeah, there we go. I'm so glad you all are here. Carrie was just telling me a little bit about what she's going to go over today, and I think it's going to be perfect for the things that you all are dealing with. So I'm not going to take up very much of her time. Just Carrie Lewis from Kentucky Fair Housing Council is here with Annie. And Annie, I don't know your last name. I'm sorry.
That's all right. My last name is Renner, so
Okay. So we're just excited that they're here today and going to share their knowledge and expertise with us on fair housing in general and then fair housing that impacts our homeless neighbors. So I'm just going to turn it over to them and let them share their wealth of knowledge with us.
Hi everyone, I'm Carrie. So what we're going to start with today is just an introduction. We're going to understand the fair housing law. We're going to go over all the protected classes. We don't have breakout sessions in this scenario. And then we'll have questions and answers. So anytime you have any questions that you need answered, if you have real life scenarios, don't hesitate to stop us or put it in the chat so we can try to help answer those questions for you. And then, so our staff is Art Crosby. I don't know if any of you guys know who Art is. He's our executive director and our attorney on staff. Then we have me, the assistant director. Amy is our programs coordinator. She helps me with the testing program and she also handles all of our intakes. And then we have Noelle Wallace, who's our AmeriCorps member on staff, who helps with Annie with intakes. And then we also have a BCTC student as well who's interning with us. So we are a nice little staff going on. So, understanding the fair housing laws and protected classes. So, Kentucky Fair Housing Council, who are we? So, we are a full service nonprofit civil rights agency. We're dedicated to eliminating all forms of housing discrimination across the Commonwealth. So, what does that mean when we say full service? That means the organization not only responds to discrimination complaints, but also provides community education and conducts outreach. We engage in advocacy. We perform proactive investigations to identify discriminatory practices before they harm additional residents. So that's our goal. So the council enforces several layers of fair housing protections. This includes the Federal Fair Housing Act, which prohibits discrimination based on those protected characteristics that we're going to go over. And then the Kentucky Fair Housing Act, which mirrors and strengthens the federal protections at the state level. And then in place where cities or counties have passed their own local fair housing ordinances where Louisville, and we'll touch on that a little bit when we go over the protected classes. And then one of the most important things to understand is that Kentucky Fair Housing Council is the only non non nonprofit private fair housing agency in the entire state. So because of that, the council serves residents in every region of Kentucky, from the large cities to the rural. So that's what we do, and we take action. So like I said, we serve the entire state of Kentucky. We investigate those claims of housing discrimination, and we are a free legal staff. So Art is free staff because we are a nonprofit, and we advocate for our clients as well. We, like I said, we do that training and outreach and discrimination testing program. If you've heard of it, what we do is we just have potential renters pose and see if there's any discrimination going in to those housing transactions, whether it be rental, sales, lending, or insurance. And what they do is when they go in, they just are there to observe what happens. It's kind of like undercover boss. He's just there to see and observe how his employees react and act to certain things. That's what we're there to do. We're just there to see how people are being treated in those housing transactions. We're not there to do a I gotcha. Oh, I can't get the next page to go. So 1968 was a story of tragedy, movement, and change. We saw the assassination of Dr. Martin Luther King Jr. on April 4th, 1968, and he was a major advocate for the open housing movement. And so, what happened after he died within 7 days of his passing was the passage of the Fair Housing Act. So, what is fair housing? Fair housing is the right to choose housing free from unlawful discrimination based on a protected class under the federal and state and local fair housing laws. Fair housing protects against discrimination in any housing transaction, whether that be rental, sales, lending, or insurance. It also includes differential treatment. So, what does that mean? That means you can't be charged higher deposits, setting different rules, or giving false information about availability. It also bans retaliation against anyone who asserts their fair housing rights, files a complaint, or helps someone else pursue their fair housing claims. So, why does this matter? Fair housing is more than just a legal requirement. It represents a commitment to fairness, opportunity, and human dignity, right? It ensures that every person, regardless of background or circumstance, has the chance to live a safe, stable, and affordable home. Fair housing principles affirm that where people live shapes their access to schools, jobs, healthcare, transportation, things like that. It protects people. Fair housing laws safeguard individuals and families from discrimination, ensuring that they aren't denied housing, steering into certain neighborhoods, or treated unfairly simply because of who they are. It builds stronger and more inclusive communities. When discrimination is removed from housing market, neighborhoods become more diverse, welcoming, and equitable. It breaks down barriers. Fair housing challenges those longstanding systems and practices. It promotes stability. Stable housing helps families put down roots. And this is part of that homelessness portion that we see. Stability is what we're looking for. And then it expands opportunity. Fair access to housing opens doors to better schools, safe environments, healthier lifestyles, and greater economic mobility. So, what are the protected classes? We have race and skin color with President Johnson enacted in 1968. And then in 74, we saw sex added. And then we saw national origin and religion, which were also included in the original. Sorry about that. Come on in, Tia. And then we have familial status and disability. And then in 2020, we saw Bostock versus Clayton enter sexual orientation and gender identity. And then earlier I had mentioned those extra layers of protection. Those Louisville extra layers are source of income, homelessness, veteran status, and criminal background. So then what are some types of properties that are covered? While single-family homes, fair housing protections apply whether the property is owner occupied, rented, or sold. Apartments and condos, that's multi-unit family housings. Homelessness and domestic violence shelters, university and dorms, rooms for rent, nursing homes, and mobile home parks. That includes like park rules, rental lots and fees and things like that for that. So then some types of examples of discrimination would be telling an applicant that a unit is already leased when it is simply not because the potential renter is Black. This is a form of race-based discrimination where a housing provider lies, right? So we don't want to see that. And then charging a tenant higher rent or security deposit because they use a wheelchair. Threatening to evict a tenant unless the tenant drops a protective order against their abusive partner. That's sex discrimination. An apartment advertisement says no small children. That would be familial status. And then retaliating against the tenant because they contacted our office. We don't want to see that either. And then I'm going to hand it over to Annie, and she's going to go over some basics of what types of discrimination we see and what those look like.
Great. So first, we're going to talk about some basic theory of discrimination. And really the ways that we typically categorize discrimination is going to be either overt discrimination or covert discrimination. So overt discrimination is exactly what it sounds like. It's that obvious discrimination that we see. So for example, we mentioned that advertisement that might say no small children. That's a very clear statement that they are not accepting applicants who would fall under familial status, which covers anyone who has minor children in their home, visiting, etc. So it's different treatment or terms based off of someone's actual or perceived identity. So even if someone doesn't actually fall into a protected class, if they're being treated because they appear to be in that protected class, they're still going to be experiencing discrimination. Covert discrimination is actually what we see more often these days, and that's when the intentions and the impact don't really match up. That can be an advertisement that says something like, "This is a quiet community." Well, someone who has small children, let's say you have 2 toddlers, you're going to see a quiet community advertisement and automatically think, oh, this isn't going to be a place where they're going to, accept us. We're going to get a lot of noise complaints. I'm not going to apply. So that ends up being covert discrimination because it may not have been intended to be discriminatory, but the way that it comes across, the way it's impacting people ends up being a disparate impact. And that is a covert discrimination example. Next slide, please. So let's talk a little bit about some policies that can end up being covert discrimination. Again, they may not have the intention to be discriminatory, but because of how they're set up, the way that they're applied, it has a discriminatory impact. So for example, a criminal background check is often a tool that's used for applicants in housing to screen tenants. However, we have to take into account things like the fact that we know that there is a wrongful conviction rate for people of color that's higher. So if it's not being taken into account that someone might have wrongful convictions on their record, things that were dismissed, expunged, etc., that can end up having that disparate impact on people of color. The same thing goes for someone who might have had an eviction. Let's say that we have a person who had a substance abuse disorder, and as a result of that, they ended up with evictions on their record. They then went and got treatment for this disorder, and now they're in a place where they can maintain housing. However, if you just look at that eviction on the record and you don't take things into account like recommendation letters from a physician who's stating that this person's ready for stable housing, it can have a disparate impact on them as well. And then again, limits on accepted income, that's something that you can see, for example, if somebody receives like a Section 8 voucher, or if they receive like a disability benefit, if you're not taking into account that this person is under a protected class, it can have a disparate impact. So people would ask, can you not use these methods to screen tenants? The answer to that is you absolutely can use these methods. However, it needs to be taken into account that there could be a potential disparate impact for things like this, and you need to look at things on a case-by-case basis and make sure that you're following policies when it comes to getting people screened for housing. So we're going to talk a little bit about Section 8 myths as well before we get into the actual protected classes. So some common myths that we hear in our office, at some of our partners here, people believe Section 8 tenants might be more likely to violate a lease, and there's simply no evidence to actually support this. The typical length of a stay for a renter in the U.S. is 2 to 3 years, but a Section 8 voucher holder is a person who's going to, on average, stay 6.5 years usually. So Section 8 tenants are actually more likely to want to stay where they're at. There was already a challenge to find housing if you're receiving a Section 8 voucher in the first place. So usually they're not going to be someone who's any more likely to violate a lease than a regular tenant. There's often the misconception as well, Section 8 tenants are entirely on welfare and don't contribute anything, when the fact of the matter is 32% of very low income tenants in our state are actually working at jobs. People oftentimes think that they shouldn't accept Section 8 vouchers because the HUD requirements are too difficult, that it's impossible to pass the inspections, the standards are way too high. In actuality, HUD has only provided a minimum list of standards, and it only addresses very basic, safe and sanitary housing. Also, Section 8 tenants don't get any special accommodations. You don't have to give them anything beyond what you would give a normal tenant who follows reasonable accommodation steps. So they still have to go through typical tenant screening. They still have to sign a typical lease, and they have to follow the same policies as everyone else if they need to request things like accommodations or modifications, which Carrie will talk more about later. So let's talk about our first protected class, which is going to be race and skin color. These are grouped together, but they are two different things. So just keep in mind if there's an instance where you're not sure that it could be either of these.
Before we get started on going through each of the protected classes, I did want to make a quick note that each of these protected classes can be affected by discrimination and it can affect their housing, which then can affect homelessness. So just keep that in mind as we talk about each of these protected classes.
Yeah, absolutely. We know homelessness has its own separate risk factors, but anyone who is a homeless person who falls under a protected class is going to get the protections of this class. So this applies across the board, obviously. So when we talk about the harassment based on skin color and on basis of race, we're usually talking about hostile environment. This can apply also to pretty much any protected class. So that's a hostile environment is when they're just making it extremely difficult for someone to enjoy their home. It can be a maintenance employee using slurs against someone. It can be a neighbor constantly vandalizing their house. Anything that makes it so that way someone feels uncomfortable, unsafe, unwelcome in their own home. There is a liability for this. HUD has a rule as of 2016 that housing providers have to take steps to take corrective action if they know that hostile environment is occurring, even if it's not their employees. If it's a neighbor, there is still liability to act. So if you have a client who's telling you that they're experiencing a hostile environment and their landlord isn't taking steps to correct that, that's an instance where we can get involved and start assisting with advocacy on that person's behalf. So just some statistics. This is over the last 2 years, if I'm not mistaken. Harassment on the basis of skin color has gone up 470%. And on the basis of race, it has gone up 114%. So there's this misconception that racism has ended in this country sometimes, and that is simply not the case by any means. So when do we know that something has crossed the line into creating this hostile environment? How can you tell a difference? It's really when harassment is based off of someone's identity. So something that could be a non-discriminatory conflict could be your music is too loud all night. A noise complaint is something that, most property managers are going to experience at some point, right? But when it crosses the line into they're making this noise complaint based off of someone's identity, they're making statements of like, oh, of course those people upstairs can't be quiet. Their kind doesn't know how to be quiet. That is harassment based off of identity. A parking space dispute when it becomes accusatory towards someone's actual identity. Oh, people like you just don't respect rules. Of course, this person with a disability placard is going to try to steal the spot closest to the door. That's harassment on the basis of identity. And that's when there is a liability for housing providers to act. So do we have any questions about race and skin color or any questions about the Fair Housing Act in general or the Fair Housing Council before we move into national origin? Give y'all just a second. Doesn't look like anybody's typing, so I'll go ahead and hand it back over to Carrie for this section on our next protected class.
Okay, so national origin. What is national origin? It refers to a broad set of characteristics related to country, region, or cultural heritage a person comes from. So what are those things? It's your birthplace. This includes the country where someone was born, whether it's the United States or another nation. Discrimination based on birthplace includes refusing to rent to someone because they weren't born in the United States, making assumptions about citizenship or favoring people from certain countries over others. Ethnicity refers to a shared or cultural or social traits such as traditions, beliefs, or historical backgrounds. And then ancestry includes the origin of someone's parents, grandparents, earlier generations. Whereas culture includes traditions, customs, clothing, practices, shared community norms, and then language is one of the most common forms of national origin discrimination. And this includes like denying housing to someone because they speak another language, requiring tenants to only speak English, mocking, harassing, or treating someone differently because of their accent, things like that. So then what are some examples of discrimination based on national origin? Stating preferences for languages. Housing providers cannot tell applicants or tenants that they must speak a certain language. Language is tightly connected to national origin, so we want to set those rules in place. Heritage based on heritage would be things like insults, slurs, stereotypes, jokes, hostile comments, selectively screening potential and existing tenants for citizenship and immigration status. If you have any clients that aren't citizens or have an immigration status, they can't selectively screen based on these things. So please reach out to our office for assistance. Refusing to rent to refugees or steering prospective buyers or renters away from certain neighborhoods because of their ancestry. And then failing to provide the same level of service or housing amenities because a tenant was born from another country. So those are just some things that we see in our office. So some best practices we like to see are those oral interpretation services, bilingual staff if we can have it, telephone interpretation lines. Our office uses Language Link, so we like to have that on ours, and then written translation services. And then we like to see them have notices to staff about recipients who have that limited English proficiency. And then also, if you guys need any help, there are like, I do believe libraries help with certain languages. So always reach out to your local library if you need help communicating with clients or if your clients need help communicating with the housing providers. Next up is disability. And this is our biggest section that we have. And some of the reasons behind this are some decreased stigma around mental health and illness, the aging population, increased support for people in recovery, and we're going to talk about that. And then there's been more activism in the disability movement. And I do know that there is a big portion of the homeless community that is disabled as well. So we see that as a lot as well. So what are some types of disabilities? Well, this pertains to visible and non-visible disabilities that substantially limit one or more major life activities. So what are some of these and what can they be? So hearing, mobility, and visual access, cancer, chronic mental illness, HIV and AIDS, intellectual and developmental disabilities, autism spectrum disorder, diabetes, epilepsy. These are just a very few small amount of disabilities. And I skipped over this one on purpose, substance misuse and alcoholism. This excludes current misuse. If they just relapse within a couple of days, that's something that we would like to still see our housing providers work with. But if they're in a long relapse, then they're not included in this. So discrimination based on disability. When is it legal or illegal to ask whether a housing provider can ask whether a person has a disability? Well, that would be it is illegal for a housing provider to ask at all if someone has a disability, and it is illegal to ask the nature and severity of that disability. But here's where it becomes legal. They're allowed to ask whether there's a requirement such as 202 and 811, which are your housing for elderly and housing for people with disabilities. Or we also have OPWA, which is housing opportunities for persons with AIDS and HIV. And then if it's an ADA unit, they can ask if a person has a disability because it has to correlate to that unit. So here's where homelessness and disability connect. People experiencing homelessness are protected under the Fair Housing Act under certain local ordinances. Like I said earlier, that Louisville has that Fair Ordinance Act. But here's a little video that I pulled from YouTube that I think you guys are, that is very impactful. And this man is homeless and he tells us a little bit about it.
It's hard. I mean, trying to find food, going to these shelters to eat, just different places, waiting for people to bring you something to eat because you got to stay with your stuff. It's things that you just can't do. You walk around in the sun all day, you're just hoping that something will come through for you. You know, the shelter is not the answer. It's just one of those things to where everybody deserves a house key, at least a place where they can rent it according to their income. Because everybody is not making $100,000 a year. Everybody, not the Rockefellers and the Kennedys and everything. So we need houses that are low income for people that would be rented to them according to their income. That's the 0 to 30%.
So I think he said it well. He has to take his things with him. And that prevents a lot of people who are homeless from getting jobs, from getting houses. Because if they can't get a job, where are they going to put their stuff? If they can't put their stuff somewhere, then, you know, if someone's going to steal it, and then they have to worry about that. And then they have to figure out where they're going to get new clothes or things like that. So it's very hard for them. And so we see this a lot.
It's hard. I mean,
what we work with. So um, it's just one of those things where we try really hard in our office to guide them and get them the resources that they need. And we see that a lot of them are disabled. And so that's why we picked this section as our biggest section. So some types of accommodations that we see for disability are, what are they? They're adjustments to rules, policies, or procedures that enable a person with a disability to fully use and enjoy their home. So how does this request work? It can be made at any time and in any format, and may be made by the tenant or someone who's helping the tenant, right? It must relate to the tenant's disability-related need. Providers must engage in an interactive process to find a workable solution, so we always want to see that. It applies to both the units and the common areas. It cannot involve extra fees, deposits, or charges, and must be allowed if it's reasonable and not cause an undue financial administrative burden. And so we see this a lot with our homeless community, where they've got put in an accommodation. Typically it's an ESA. They've been charged a pet fee and a pet deposit, and then they can't get the correct documentation, then they get a lease violation, and then they get a lease termination. And then they've lost their housing by the time they've realized they're supposed to call us. So that's why we're educating everyone. We're educating you guys to let you know these are some of the common things that we see in our office, as to not necessarily the reasons why people are homeless, but there are some types of reasons why they are, and this is what we see. So emotional support animal, like I said, what are the two types of animals? There's a pet and an emotional support animal. These can be a variety of types. Where a pet is for companionship, an emotional support animal is for a disability related need. A pet, they can charge pet fees, pet deposits, but for an emotional support animal, they cannot. And that's what I was talking about. Fees, all those fees that can be charged. Here, they cannot charge this fee, but they can require vaccinations for both. Training is not required for either one, and they must clean up after their animal, and they can be charged for damages for their animal. So acceptable documentation, they need a letter from a licensed medical professional who treats the patient's disability, and that needs to have the medical professional's name and address on there, their license number. It needs to state why the person needs that emotional support animal without disclosing the disability. And then it needs to be signed and dated. And then they can also ask for vaccination records and local licensing records. So those are the types of documents that need to be turned in when they're being asked for an emotional support animal. Some simple types of reasonable accommodations would be landlord allows a live-in aide to help a tenant with daily living tasks. A landlord makes an exception for a tenant not having a recent rental history due to time in a mental health inpatient facility by accepting reference letters. That could also go for people in sober living homes, things like that. We want to see reference letters like that. If you're in a homeless shelter, maybe you can get a letter from your homeless shelter who's running the homeless shelter saying, you know, Mr. Smith comes to the homeless shelter every day, but he cleans his bed. He's very responsible. He stays around and helps us clean up afterwards, things like that. A nice recommendation. We like to see that as well. Landlord assigns a parking spot to a tenant in a first come, first served lot because the tenant uses a wheelchair and they need a handicap accessible parking spot. And then the landlord lets a tenant out of a lease penalty free after the tenant gets into an accident and is medically deemed to have a disability and can no longer access the unit. So reasonable modifications, this is what's up next. What is a modification? It's a structural or physical change to a unit or common area that a person with a disability needs to fulfill and enjoy their home. So this can include the interior and exterior of the unit, and it can be made in the common and public use areas as well. So who pays for this? Housing providers with federal funding must pay for the modification. All other housing providers, the tenant may be responsible for the cost. And then a reasonable restoration deposit may be requested when the change affects future renters. So reasonable modifications. Rules housing providers must follow. They must allow the modification as long as it's reasonable. They must give you must get permission before the work begins. So let the clients know that if they do have, they do find housing and they need work done, that they should have somebody else do that first, and they need to get permission. And then it may require to be done by a qualified professional. And then what providers may request that explanation between the disability and the related need if it's not obvious. Sometimes they'll ask for a description of the proposed work, say there's a ramp to make sure that it's being built right, and then an agreement to restore only if the change affects future tenants. So some examples of reasonable modifications would be the landlord approves the tenant's request to have grab bars professionally installed in the bathroom to assist with mobility. A tenant who uses a wheelchair is allowed to add ramps at a front entrance to improve accessibility. The landlord then grants a request to install visual smoke detectors and flashing doorbells for a deaf tenant. Or a tenant with limited vision is permitted to install those tactile labels on appliances and light switches. And then a housing provider allows a tenant with arthritis to replace standard doorknobs with lever style handles. And then adjusting the height of mailboxes for people in wheelchairs or scooters. That's the common use area. And then a tenant is allowed to install a handrail along the hallway to safely navigate the space in the common use area. So those are some types of reasonable modifications we've seen. And how to handle these, we would like to see our housing providers highly made all these requests in writing, even though they don't have to be, but we recommend it. If the disability is not readily apparent, have them document their disability. That helps. Documenting everything will help your clients, whether that be related to us or anything else. Please have them document everything. Next up, the request must be related to the disabilities, the tenant's disability. And then we like to see them try to maintain that interactive process that is part of fair housing. And then a retaliation for making any reasonable accommodations or modifications is a violation of the fair housing law. So next up is religion, and I'm going to give that to Annie. Does anybody have any questions about disability and how that impacts homelessness? I do see one question in there. Can a management company require a tenant to complete ESA paperwork provided by the company, or do they just have to accept the letter? They only have to accept the letter, Carol. It's the letter, the vaccination record, and the local licensing letter. Anything after that is deemed undue burden on the tenant, and the law only requires those three things. So any extra paperwork they do not have to fill out. That's a good question. That goes for any type of accommodation or modification request that they have regarding whether it's emotional support animal or not. That's a good question. Anybody else have any questions before we move on to religion and how that may impact homelessness? Okay, Annie, I'll give it to you.
We do actually have another question here. Does the letter need to be on the doctor's letterhead? And the answer to that is yes. Any ESA documentation letter should be on the letterhead. It should have the name of the physician who's providing that information, their contact information, and their license number information. That should all be included there. Okay. Do we have any other questions about reasonable accommodations, modifications, or anything else related to disability as a protected class? I think we'll go ahead and move on then. Thank you so much for your great questions. We really appreciate it. So we'll talk about religion. And religion was one of the original protected classes added to the Fair Housing Act back in 1968. Religion is actually our least reported protected class in the state of Kentucky. And typically that's how it is throughout the country. But we want to make sure that people understand that religion doesn't just cover, someone calling themselves like an Abrahamic religion or something like that. It is much broader than just someone's religious label and just specific religions as well. So it's including but not limited to someone's religious attire. So if someone wears a head covering of their choice, that's protected. Practices or rituals within reason are always covered. There's also the non-practice of religion. Atheism is included, and non-mainstream religion. So that's anything that doesn't fall under, one of our mainstream religions, like the Abrahamic religions, Hinduism, some of the things that we see more often. It's going to protect people who, for example, call themselves spiritual but don't have a religious label. It's going to protect people of uncommon religions like Sikhism. We don't have a lot of Sikh folks in the state of Kentucky, but they're all still protected. Anyone who has a religion at all or not has religious protections as a protected class. Yes, Carrie? Did you have something? Oh, sorry. Okay. Next slide, please. So some of the more common examples of religious discrimination that we typically see would be a leasing agent refusing to give a woman an application because she wears hijab, a realtor trying to steer a Jewish couple into or away from specific neighborhoods because of their religious affiliation, or allowing some tenants to put up their religious decorations but telling other folks that they're not allowed to do that. So for example, if there's like a common space at an apartment complex and they allow folks to put up a Christmas tree, if someone shows up and says, hey, may I please put a menorah up in this space as well, that would have to be accepted, or it's going to be religious discrimination. If there is an overarching rule that applies to everyone, that there's no religious decorations in a common space, that would not be religious discrimination as long as it's being applied evenly to everyone. So best practices to avoid religious discrimination is making sure that there's an anti-harassment policy that's clear in a lease. If you have a client who's signing a lease, they should be able to find this in the lease that they're signing. If there are cases of harassment, housing providers, again, have to show that they're taking corrective action. That hostile environment rule applies to all protected classes. And just remembering equal access doesn't mean equal outcomes, and housing providers can still be held liable for discriminatory practices, even if it's between their neighbors or tenants. Okay. Are there any questions about religious discrimination before we move on to our next protected class? Okay. In that case, I will hand it back to Carrie to talk about familial status.
Okay, so familial status. I don't know what. Okay. This includes households with children living in the home that are biologically related to the adult or not biologically related to the adult, because I have adopted children and foster children and visiting children up there, and children temporarily staying with residents. So what does that mean? Adopted children are treated exactly the same as biological children under the Fair Housing Law. Whether the adoption is formal, in progress, finalized, they are protected. Foster children are the same way, even if they're just temporarily there. And then visiting children, my favorite, whether they're there for weekend visits, summer visits, or court-ordered visitations, they're still protected under the Fair Housing Law. And then, so some simple types of examples of familial status discrimination will be only showing families with children apartments on the first floor because children make too much noise, and we know that noise complaints are very fair housing sensitive. Refusing to rent to an applicant with children because the rental home has lead paint. My favorite thing to say is change the lead paint. It's the parent's job to watch whether the child eats it or not. Terms or rules that specifically single out children. So we see this at pool time. We don't want to see things like, if they're stating things like no children till 12 o'clock, then that's narrowing their time. And then advertising that children aren't allowed, we see that a lot. Or we also see quiet neighborhood that could potentially steer families away from that neighborhood as well. So then occupancy limits, there's this 2 bedroom per, or 2 people per bedroom rule that shouldn't be applied with that broad brush, right? So we want to see everyone sticking to that code, whatever's their local code for your occupancy limits. Not that also we see sometimes people call about gender or age groups. There's no, that's up to the parents. Housing providers should not be involved in that. So we want them to do that. And then I have Louisville on here follows that rule for code. Everyone should just be following that code for square footage. And then be cognizant about language and policies that single out children. Those noise complaints, like I said, are extremely fair housing sensitive. And then occupancy should follow the code. And then our last section is sex, gender, identity, and sexual orientation. Does anybody have any questions before we get into that section? Okay, I'll give it back to Annie, and Annie's going to discuss some domestic violence in this as well. So keep in mind this affects homelessness as well.
Thank you, Carrie. So when we talk about sex or gender discrimination, it's going to have a lot of things under the umbrella. You can use sex or gender discrimination interchangeably. I typically use sex discrimination. I feel it covers, the whole category. But when we talk about sex discrimination, it's going to include gender identity and sexual orientation. It also includes sexual harassment and domestic violence. All of these have their own protections that are separate from each other, but they all fall under this umbrella. Next slide, please. So when we talk about gender identity and sexual orientation based discrimination, it's important to note that we do have this existing executive order that was issued under the current administration. What this does, this order, it has a very long title you can see there, but it's Executive Order 14168 that was passed last year, or signed last year rather. And this withdrew some previous orders from the previous administration that had added some layers of protection for gender identity and sexual orientation. However, with that said, we still have the original ruling of the Supreme Court case, which was Bostock versus Clayton County. Bostock versus Clayton County was an employment case on the basis of gender identity and sexual orientation, but because the terminology under the Civil Rights Act for employment is so similar to the Fair Housing Act, it's considered to apply still to the Fair Housing Act as well. What this does is give some specific protections for gender-based discrimination. There's also local ordinances in play. So several communities in Kentucky have passed their own fairness ordinances, including Louisville and Lexington. So this protects people who identify as LGBTQ+ from discrimination in employment, housing, and public accommodations. So as it stands, sexual orientation and gender identity cases are still considered harassment. Keep in mind, this is changing pretty rapidly. If you ever have questions, please reach out to our office. Next slide, please. So what's some of the most common gender identity and sexual orientation complaints that we see at our office? So we'll often see issues like providers refusing to rent to same-sex couples based off of their family composition, or refusing to allow someone to add a partner to the lease if they're a same-sex couple. So our examples are refusing to rent a home, or a leasing manager at a 55+ community rejecting a request to add someone to the lease. There's also issues if, for example, an employee sees that a tenant has a daughter who has a girlfriend, and that manager has an issue, or the maintenance employee has an issue with a teenager's lifestyle, and then refusing to fulfill any maintenance requests, telling the tenant that they're going to have to take care of that themselves. And then we can see steering in let's say an example we have here is a realtor refusing to show homes to a potential buyer because of that buyer's gender identity. All of this is harassment that is still enforceable under the Fair Housing Act as illegal discrimination. Next slide. Okay, so let's talk more about sexual harassment now. This is our separate category. And like I talked about before, hostile environment does apply to sexual harassment. We often see sexual harassment either fall under that hostile environment, where there's a threatening, unsafe, uncomfortable environment because of unwanted sexual advances or sexual behavior. We also see what's called quid pro quo, or this for that. So that could be a housing provider or an employee asking someone for sexual favors or sex in order to avoid things like late fees on rent, excused completely free rent, to avoid an eviction. And all of this can come from employees, managers, property owners, neighbors. And it doesn't matter about the sex of the person doing the harassment. I see you've got a hand raised here.
It's Laura. I have
Hi,
a
Laura.
question. I have had this happen to me. I've seen it happen to clients over the years. Like maybe a maintenance person or the leasing manager, somebody at a property that will refer to all of the women as hun or sweetie, and men are just called by their name or Mr. So and so. But anytime they interact with a woman, they've got to use that term of endearment. Where does
Yeah.
it fall in this?
So I feel like that's going to fall under more of a hostile environment, right?
Okay.
So the maintenance employee isn't asking those people, oh, if you want me to stop calling you sweetie, then go on a date with me. So it's not going to be quid pro quo, but it's making that uncomfortable environment. The key with a situation like that would be, if you told the employee at your apartment, hey, can you not call me honey? I don't appreciate that. And then they persist after that point, it's definitely becoming a hostile environment and would fall under sexual harassment at that point. There has to be usually some kind of, you got to call it out, correct the behavior. Some people, for example, older people might use terms of endearment more often and not realize when it comes to this specific type of scenario, if it continues after something is deliberately said, then that could be a point where you could call a fair housing council. Does anybody have any other questions about quid pro quo or hostile environment? And Laura, do you feel like that answered your question?
Yeah, and I have called it out. Usually, if it's
Okay.
an older person, they're doing it to everybody. They just don't
Yeah.
remember somebody's name, and so everybody is sweetie. But
Mhm.
I've also seen it where, it's only directed towards females and not males.
Yeah.
And
Yeah.
I've
So
called it out
it's
too.
deliberate. It's
Hmm.
deliberate and it's been called out and it continues. That's definitely something I would consider a hostile environment if it's making you and other tenants uncomfortable,
Hmm.
for sure. And then again, that's a situation, it's hostile environment. Even if it's a maintenance employee, the property management, the housing provider, the landlord, they have an obligation to act if it's brought to their attention. Okay, I think if we don't have any other questions on sexual harassment right now, we can go ahead and go to our next slide. So we've got some common discriminatory practices that can fall under sexual harassment. So if a woman asks to view an apartment and the landlord offers to take her on a date to review her application, that can be an example of quid pro quo. A leasing agent makes regular comments about a tenant's body, often commenting about how he looks when he's visiting the facility gym, even after he's asked her to stop. So that's kind of similar to that situation that Laura was mentioning, and I would consider that hostile environment. And then a tenant makes a report because a maintenance worker keeps making lewd remarks, making a hostile environment. And ever since they filed the report, they're no longer receiving any responses to their maintenance requests. That's clear retaliation for making a report of sexual harassment. And let's say if that maintenance worker then showed up and said, you know what, I'll come back and make repairs if you do this sexual favor for me, it's going to be quid pro quo as well. So we often see situations where it's been a hostile environment for a long time, and then a tenant suddenly receives an eviction notice and they don't have any options. They have to avoid homelessness. And then the landlord shows up and says, hey, can you let's have sex. And then I'll forget about this eviction. I'll dismiss it. We actually had a settlement very recently in a case here in Lexington where we had a landlord who created a hostile environment. His employees were involved in creating a hostile environment. And he actually did put hands on some of his tenants. So we got a settlement against, I believe it's Adnan Mohammed Chalash and a lot of their family members who property had been transferred to. And the settlement was $850,000 for the survivors of that sexual harassment and abuse. So this is something that's absolutely being enforced, and people are being held accountable for these actions. Next slide, please. Okay. Let's talk more about domestic violence and fair housing. So domestic violence has its own protections under Federal Fair Housing Act. We've also got additional protections for survivors under state law and under the Violence Against Women Act, which is another federal level act. A lot of these protections can overlap with each other, but they all have their own eligibility requirements for these protections to come into effect. Usually that's going to be some kind of active protective order, and it may be a full protective order. Sometimes the emergency protective order is not enough. Next slide. So when it comes to best practices for domestic violence, the things that we like to see is that housing providers are honoring things like a lock change request after somebody has reported abuse. We have the opportunity under the state and under VAWA law to get no trespassing orders against abusers who are named in an active protective order, allowing someone with a protective order to transfer to a different unit or even terminate their lease early if it's not a viable situation for them to move to a different unit is another best practice, and that's something that's permitted specifically under the Fair Housing Act. And then making sure that housing providers are always referring to VAWA guidance, and you with your clients understanding what the VAWA guidance gives them. If you have a client who's entering into a property that receives any federal funds at all, then they get VAWA protections, and they're supposed to be notified of their VAWA protections at the time that they sign their lease. They should get some documents that let them know about the opportunity to self-report their status as a domestic violence survivor and informing them of their rights. Okay, and that is it for sex-based discrimination. Does anybody have any questions about domestic violence protections, sexual harassment, or gender identity and sexual orientation? See. Can we talk more about the last slide? Yeah, so this is a little bit more of a compacted version of what we talk about when it comes to domestic violence. So with domestic violence protections, where we've got these different layers, Fair Housing Act, VAWA, and the Kentucky state law, certain aspects are going to cover certain protections. So the Federal Fair Housing Act requires an active protective order, and that allows people to do things like transfer to other units, get early lease terminations, things like that. State law allows for things like putting people on no trespassing orders, getting those lock change requests, and also some transferring to other units. It lets the landlord take some extra steps as well, like if the abuser is still listed on the lease, they can go ahead and evict that abuser. Or if somebody needs to go ahead and terminate the full lease, state law lets them do that too. VAWA is a bit of our outlier. So that's the Violence Against Women Act. And that only applies to federally funded properties. So if they receive any kind of subsidies, low income properties, it's going to have protections for survivors under the Violence Against Women Act. The Violence Against Women Act, to receive those benefits, you can self-report. So there's a specific form that HUD provides to people where they can go ahead and report, yes, I'm a survivor of domestic violence. I want to make sure that I have these protections, and it also protects people in their home. VAWA also includes some protections for people who have experienced sexual assault, dating violence, and stalking. Do you have any other questions about specifics for domestic violence? Yes, Laura.
We're going to do a whole training just on VAWA on April the 8th. We've got somebody from Zero V.
Awesome.
And this is one topic that we feel like deserves its own hour and a half every year. So
absolutely,
watch your emails for the invitation coming up on April 8th.
I would love to be there.
Oh, good.
Yeah, because I know I'm the one who does a lot of our domestic violence cases and just sex-based discrimination in general, and I could probably present for an hour and a half just on the domestic violence protections,
Yeah.
let alone VAWA. So I really
Uh-huh.
appreciate that you all are going to have a deep dive into that subject because it does get much more complex than what we've touched on today.
Yeah,
That's
and
what
our
we've got time for.
HUD projects are required to have those VAWA forms in the files
Yes.
and that those protections get posted and things like that. So everybody just know that if you're nervous about VAWA, more is to come. Keep your eyes on your emails for that.
So I'm really glad to hear that you all will get some more specifics because it does get pretty advanced. But I'll go ahead and hand it over to Carrie to wrap things up. And if you all have any questions, we'll have an opportunity for that at the end too.
So get involved with fair housing. Pass this information along to your neighbor, to your coworkers, to who couldn't be here today. Sign up for our newsletter and get monthly information about housing. We put information about what we're doing, about what other organizations around us are doing. Volunteer to be a discrimination tester. I know there's a couple of my discrimination testers out in the audience right now. And then schedule a training with us for your organization. If you want a deep dive into anything, we can deep dive into that. And then plan an event, a table. We can table any event. We'd be more than happy to come. If you have events that you think we'd be interested in, please let us know. And I do see we have a question. Oh, thank you. Yes, I would love to learn more. So yeah, that's it. Here's our information. Does anybody have any questions? And I think that QR should still work for our newsletter. Do we have any questions about any of the sections we went over?
Can you send me a copy of your presentation?
I absolutely can.
Okay,
Yes,
and I'll email it out to everybody that logged in today.
yes, absolutely. I know we just short and condense that, but
Mm.
yes, thanks everyone for your time and attention and great questions that you guys had.
Well, and to all the participants, you now have some experts that you can reach out to if you leave this session and later think, oh, I wish I had asked this, or oh, what about this situation? Then you know who to reach out to and who you can ask that question directly. I appreciate Carrie and Annie making themselves available to us today. This is such an important topic for what we do. So I really appreciate you giving us resources and giving us your time today.
I did have to see one question in the chat from Heidi. She says, are there handouts we can give to our clients? I will email over all our brochures as well to you so that you can send them out to all the participants.
Okay, yeah, just send it to me and I'll do a mass email for it.
Yep, that'll work.
Or if
Or anybody can reach out to me. My email's right on there, or Annie, and we can email you any of the brochures that we have on file.
yeah, go to their
Absolutely.
website too and play around with it a little bit, see what's on there. There's good information and sign up for that newsletter. There's always a wealth of information that comes out in that newsletter. If policies change, laws change, that's a good way to get a heads up about events, opportunities. So yeah, sign up for that.
Absolutely.
Okay. Well, you'll send me the information and I'll forward it out to
Yep.
everybody and let everybody get back to their days.
Awesome. Thank you guys for your attention.
Thank you so
Thanks.
much.